The side chat has me cracking up, so I'm going to be reading it. That's why it's minimized. But welcome back to Crimes, Lies, and Alibis. I am Nicole, and I'm waiting for them to go live in the courthouse. We will see if Lori is still going to rest. And if she does, then it's closing arguments, and I don't anticipate it is going to take long for the jury to come back. And I think they're going to find her guilty because she really didn't prove anything. But I think she also knew that. I think she knew that they were going to find her guilty and that she was guilty of sin. She just wanted the attention from being in court. So she wanted, I mean, I'm guessing. I don't know for sure, but.
Oh, dish soap is on sale.
Oh,
we need
Lord.
it?
Yeah.
Go
Oh,
away.
I think we need ketchup too.
What's in there?
Go away. Apparently, they are reopening the investigation for Kylie's dad. Kylie Ryan's father. I thought I had seen that they were looking into too bad they can't. Too bad that Tylee's bio dad. Cause of death. Too bad Tylee's bio dad was cremated. Wow. Spell that correctly. Oops, I put bio dads. I wish you could edit comments because now I look like an idiot, but he died of natural causes the year before in 2017 before all this happened. So I just think it's really weird, all of these people around Lori who are dead. And I firmly believe the only reason Colby is still alive is because he was an adult and already out of her care at the time. But if he were also a child, yeah, someone agreed with me. I'm convinced that Colby being an adult saved his life. He's still here because he wasn't in her care and custody. And if she could have gotten money out of him, his team Ned in the chat. Oh my God. I agree 1000%. Crime size and alibis. The Pope died for Lori's sins. Oh, jeez. Nancy. Nancy Murfield. Make sure it's a $300 shirt. Make sure that it's a $300 bamboo shirt because it's basically Kevlar, according to Lori. All Ned. I love the chat. It's hysterical. We're all Ned with little zombie emojis. Okay, come on.
All right, we're on the record, State of Arizona versus Vallow Daybell, CR 2021-001704. Why don't I have the state announce? And the defendant?
Vallow Daybell?
All right, we met on Thursday and went over jury instructions. In the meantime, since Thursday, there was a few modifications sent out. We put drafts on your desk this morning. Last week, let me just pull up that email.
No eating reports, please.
Judge McSteamy.
Last week, the state requested some modifications that were made, and then on Friday, Advisory Council also requested a correction to the presumption of innocence, which I did do, as well as a mere presence instruction. Does anyone want to make a record on any of those changes that have occurred since we met Thursday? I forgot, I don't know if my staff told you, I did add, I realized standard number 9 was not added, which is defendant need not produce evidence, so I added that this morning as well. Have you had a chance to review the latest draft, or do you need more time? We told the jurors to be here at 11, so we have time if you need more time. Any other record you want to make on mere presence? All right, has the defendant had a chance to review the final instructions?
Yes, Your Honor.
Any additions or corrections?
No, Your Honor.
All right, we're still waiting for a few jurors to show up. The plan this morning, well, let me ask the defendant, you still plan on resting?
I do.
Okay, so when the jury comes in, I'll remind them that the state rested last Wednesday, and then I'll turn to you and you'll presumably say the defense rests. I'll read the jury instructions and we will break after I read the jury instructions. Depending on what time we break, I'll tell them what time to come back for the closing arguments, approximately an hour later, or around 1 p.m. While we're waiting, I had my staff
No.
Do not buy new windows if you live in Georgia.
No.
Americans living in zip codes starting with
No.
30, 31, and 39 are
Skip.
being paid to switch to energy
Thank
efficient
you.
windows.
There's a second phase of this trial for aggravation. In addition to a dangerous finding, does the state know what other aggravators it might be pursuing?
Potentially the emotional harm to the next victim.
Anything else?
The presence of an accomplice.
Okay.
That should be it.
And in the event that happens, would you be producing testimony or evidence, or would it just be argument?
Potentially testimony from next defendant.
Okay. All right. So how many jurors? You can go ahead and print out.
Your Honor, I have two issues I'd like to bring up real quick.
Go ahead.
The jury process of the jury alternate selection. Can you tell me what that process is going to be today?
It's literally drawing two numbers out of randomly out of a container.
Lori, you have far more than 2 issues, lady.
When is that going to be done and how does that
Not
work?
till after the closing arguments.
Okay.
So the alternates are told that they're still alternates, they're not released, because I have had in the past jurors become sick or ill or not be able to deliberate, and we have to call back an alternate to deliberate. So they're still under the admonition until they're released.
So we're keeping all of them, basically.
But only 12 will go back and deliberate.
Okay.
If one of those 12 becomes sick or is unable to deliberate, we would bring in an alternate and release the person that can't deliberate. Does that make sense?
Yes.
All right, what else?
So it came to my attention this weekend that the exhibit number 286 that the state put into evidence that Detective Inkland testified to was the full interview is only about 21 minutes long, and the actual interview is about 55 minutes long.
Remind me, what's 286? Whose interview?
It's my interview, I guess, with Detective Inkland.
I think that's been redacted because the full interview wouldn't be admitted into evidence for the jury to review. Is that correct?
Correct.
All right.
So is it just the snippets that were played all together?
It should just be the parts that were played in court. Is that correct?
Yes, I mean, they're all connected, but
All right.
the state redacted out the beginning, the end discussions of highway, that would be hearsay or not.
Right. So did you have a question about that?
Yes. So is it just the snippets all put together, or is it the interview for the first 21 minutes?
I think it's just the snippets that were played in court that are put together as one exhibit.
There's connectors between all of it, but it does not include any of the beginning or the end of the interview.
Right, portions have been redacted out.
Yes,
But it's just more or less what was played during testimony.
correct.
Does that answer your question?
Kind of, but Detective Inkland testified that it was the full interview. So what does that mean if she testified that it was the full interview?
I don't know. It's something you could have cross-examined her on, but now it's probably too late. If you wanted clarification on that. But the jury is going to know it's redacted, and they get the redacted exhibits instruction as part of the instructions. So either side can point that out to the jury that it's redacted. Anything else?
I would love to see her pull a Taylorship
I was just
business
assuming
and
that
get
might
like
have been an error
tackled.
to say that it was the full interview when it wasn't the full interview, and it was admitted into to reflect the record that it was the full interview. So are you telling me that the jury is not going to be able to go back and watch the full thing?
Your full interview?
Correct.
No, because it was never admitted into evidence.
But that's what they said was admitted into evidence.
I don't remember if that's what was said or not. I would be surprised if someone said your entire interview was being admitted, but I don't remember the
Well,
exact
my advisory
testimony.
council checked the FTR, and that's exactly what was said. That's exactly what I was shown, that it said, is this the full interview? Yes, this is the full interview, and it was admitted into evidence.
Was there sometimes they enter in the full interview for appeal purposes only, but that's not the one that actually gets shown to the jury. Was that the case?
It was not for appellate purposes, Your Honor.
Okay.
It is the full interview. The defendant talks to the detective in the beginning about Kylie, does not include that. She talks to the detective at the end about Kylie and victim services. It doesn't include any of that. She's sitting in a room for I don't know how long while Kylie's being interviewed. It doesn't include any of that. It is her interview about what happened.
Okay. So the states closed their evidence.
I'm just trying to find out what the jury is going to be seeing. They have all that evidence in the evidence when they deliberate. Is that correct? They
Whatever
have
was
access to that.
whatever was admitted into evidence, which portions of your interview were not admitted into evidence, it sounds like.
Lori has a room temperature IQ.
From what I'm understanding from the state, just correct me if I'm wrong, it's not just the snippets that were played, but it's a partial part of the interview, and some of it was redacted. Is that correct?
That's what I'm understanding. The parts regarding what Ty Lee said or did or didn't happen, the hearsay parts were, the start and the end were redacted out.
And then what was meant by the testimony that this is the full interview?
I don't know. I guess that's something that someone could have asked that witness. Maybe it was the full interview of your version of what happened.
So we have
There.
our Exhibit 20, the defense's proposed Exhibit 20, is the full interview. Can we replace that one with the full interview since it was entered into evidence as the full interview?
No.
The wheel
not?
is spinning, but the hamster
The
is
full
dead.
interview won't come in because it's
She's so dumb.
a significant amount of hearsay within that interview that's not admissible evidence.
It was admitted as the full interview.
Well, if a witness testified that it was a full interview, either side could have clarified that with that witness. I don't know what that witness meant when they said that. Anything else?
That's it.
All right, we're getting the sufficient number of the jury instructions copied. As soon as that's done and our jurors get here, we'll read those instructions. All right.
You'll be back on the record in 15 minutes. Oh, my Lanta. So, if anybody is confused, I don't think it's very confusing. But her argument is that she wanted the whole video shown. And she can't admit the whole video into evidence because it's not her evidence, it's the state's evidence. So she's only allowed to go off of what the state shows. So the state did not bring forth the whole video. They only brought forth snippets. They redacted the parts out where she mentions Tylee, in the sense that Tylee did this and Tylee did that day, because that's hearsay. Tylee isn't here to be questioned by anyone because she's dead. And she's dead at the hands of her mother. Like I said earlier in the video I did this morning into this afternoon, if Tylee had died in a car accident, or if Tylee had died to an external source that did not involve her mother, but she committed suicide, or she did another act that ended her life, or if something happened to her that was an accident, then it would have been admissible as evidence. But because Tylee died at the hands of her mother is not allowed to use her as a tool in this case, which, in my opinion, was a very good decision that the judge handed down. That was righteous. That was right. She shouldn't be able to use her daughter's testimony or daughter's comments that, you know, she's the reason that Tylee's not here. But that's very frustrating to her because she wants, well, Tylee, you know, she wants to be able to utilize that Tylee came out with the bat and that he pulled the bat from her hands and all of the things that go into what allegedly happened. But if they listened to, and actually, it would have helped, I think, the defense if they would have heard, or the jury, if they would have heard part of Tylee's statement, because Tylee says that she fell because she lost her balance when she let go of the bat. That Lori told her to let go, and she did, and that's why she fell. She didn't fall because Charles struck her. She didn't fall because of anything he did to cause her to fall. She fell because she lost her balance. And she testified to that. So, or she stated that. So I really don't think it helps Lori if they would have used her statements, because it directly contradicts. If anything, it kind of did help her. Not that there really was much help, but if you want to go by the video standpoint only, nothing is saving Lori from this. They're going to find her guilty, and I feel they're going to find her guilty very quickly. there isn't a question in my mind that they're gonna find her
For
guilty.
premium home services, expect excellence
Sorry.
with Ragsdale, the name you know you can trust.
Athens Ford, your real hometown Ford dealer, is proud to present factory employee pricing during the From America for America event.
Yes,
Get
Athens
exclusive
Ford.
employee pricing on the Ford.
For people who are like, this is a waste of taxpayer money and all of that, no, it's not. In the American justice system, we should support justice. And even if she's not going to get out of prison and this just adds more time or whatever, I mean, sure, yeah, it's, this trial wasn't super necessary in the eyes of, it's not going to change Lori ever getting out of prison. But it's recognizing that Charles was not only treated unfairly in life, he was also murdered. It wasn't self-defense. It wasn't he was losing his mind because he wanted something bad to happen to Lori. He wanted his phone back. He wanted to spend time with JJ. That's so this isn't about giving Lori more time. No one cares about that. It's about seeking justice for Charles and clearing his name so that his family can have that closure. So his family can say, she was found guilty of this. She was found guilty of conspiracy. That Charles was not a bad man. That he did not deserve to die. That he wasn't attacking Alex or Lori or Tylee. That he was just there because he wanted to see his son. That's it. That's what it boils down to. And by doing this, they get that peace and that closure. No one cares about Lori. I mean, I'm sure there's someone out there who cares about Lori. But anybody sane doesn't care about Lori. It's all about having justice for Charles, and so that his family can close this chapter of their lives and know that justice was served. So people can say this is a waste of money, and maybe for, some people it is. But in my opinion, this is about justice, and this is about closure, and this is about accountability. Lori needs to be held accountable for all of her crimes. Her conspiracy crimes, her murder crimes, her fraudulent crimes. Call her to the table for everything and hold her accountable for everything. Because she is going to go down in the books as being a mentally ill, horribly evil woman who is a master, not really a master, but a manipulative, cruel individual. And I say cruel because texting his child the next day to tell him that his father was dead and then ghosting him is beyond cruel. Like, to me, that is just beyond cruelty. It's cruel. Texting your stepson to be like, your dad died, and no other context, no other relation, no other anything. I'm just gonna text him and let him know that his dad died and then ghost him. So for him to discover what happened to his dad, he has to Google it. It's disgusting and cruel, mean. It's terrible. That is terrible to do to someone. I just can't imagine being that kind of a person who decides to do that. Like, it's cruel. Unbelievably cruel. Someone said the inmates in Idaho must where'd it go? Can you imagine the inmates in Idaho? They have a vacation from Lori Daybell Vallow's nutbag, and now she's gonna go back there. And I said, they must be basking in the peace. Her teaching them yoga. Okay. Teaching them yoga. Like, This woman is so unbelievably full of herself. Oh my god. Lori will return to prison and start online law classes. And how to make chicken enchiladas. She should work in the kitchen making those flavorless, unmemorable green chicken enchiladas. Oh my god. Woman's a nutball. Someone said, here we go. Did the jury come in? I'm confused. I'm gonna miss this little hottie judge. People are funny. Oh my god.
All right, that's fine. All right, we're back on the record. State of Arizona versus Daybell, CR 2021-00170.
Say hello to Zaxby's Southern Fried Shrimp. You can shrimp it on a salad, shrimp it with fingers, or shrimp it in buffalo sauce. At Zaxby's, there's no...
Tell my husband I want Zaxby's. Just kidding, I've never eaten there. I wonder if we're having rice for dinner. We have one of those hibachi style grills on the garage that we put rice on and stuff, and it's so good. But anyway, now I'm hungry, and it's only 2:30. Ugh. Oh, whatever, Waltz.
All right, please be seated. The jury is present. Welcome back, members of the jury. Last Wednesday afternoon, the state rested its case, so now I'll turn to the defendant.
The defense also rests, Your Honor.
All right, at this time, that concludes the evidence portion of the trial. I'm going to have my staff hand out to the jury the final jury instructions.
Why can't anyone answer my question? After Tammy's death ruled a homicide, why wasn't Chad arrested? It's possible.
Okay. The jurors have the instructions. Much like the preliminary instructions, you can either follow along with me or just listen. I need to read these into the record. Duty of jury. It is your duty as a juror to decide the case by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide this case. It is your duty to determine what the facts are in the case by determining what actually happened. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and the exhibits introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel I have about the facts. You, as jurors, are the sole judges of what happened. You must consider all these instructions. Do not pick out one instruction or part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them. Evidence to be considered. You are to determine what the facts in the case are from the evidence produced in court. If the court sustained an objection to a lawyer's question, you must disregard it and any answer given. Any testimony stricken from the court record must not be considered. Rulings of the court. Admission of evidence in court is governed by rules of law. I have applied those rules during the trial and resolved any issues concerning the admission of evidence. If an objection to a question was sustained, you must disregard the question and you must not guess what the answer to the question might have been. If an exhibit was offered into evidence and an objection to it was sustained, you must not consider that exhibit as evidence. If testimony was ordered stricken from the record, you must not consider that testimony for any purpose. If evidence was admitted for a limited purpose, you shall consider that evidence only for that limited purpose. Do not concern yourselves with the reasons for my rulings on the admission of evidence. Do not regard those rulings as any indication from me of the credibility or weight you should give to any evidence that has been admitted. Direct and circumstantial evidence. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence regardless of whether it is direct or circumstantial. Redacted exhibits. Some of the exhibits that have been admitted into evidence have had portions deleted from them for legal reasons. Do not concern yourselves with the reasons why some portions of the exhibits have been deleted. Do not speculate upon what the deleted portions might or might not reveal. Indictment is not evidence. The state has charged the defendant with a crime. A charge is not evidence against the defendant. You must not think a defendant is guilty just because of a charge. The defendant has pled not guilty. This plea of not guilty means that the state must prove each element of the charge beyond a reasonable doubt. Self-represented defendant. The defendant in this case represents herself. All instructions I read to you that include references to lawyers or attorneys apply equally to the defendant's self-representation at trial. The defendant's decision to represent herself should not be considered by you when determining the facts. Comments are not evidence. In their opening statements, the prosecutor and the defendant talk to you about the law and the evidence. In a few minutes, the prosecutor and defendant will give their closing arguments and will talk about the law and the evidence. What they said or say is not evidence because it is not sworn testimony, but it may help you to understand the law and the evidence. Credibility of witnesses. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says or part of it or none of it. In evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness had any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before trial or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in the light of reason, common sense, and experience. Testimony of law enforcement officers. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. You are to consider the testimony of a police officer just as you would the testimony of any other witness. Expert witness. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it, in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. Defendant need not produce evidence. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce evidence is not evidence of guilt. Defendant need not testify. The state must prove guilt beyond a reasonable doubt based on the evidence. You must not conclude that the defendant is likely to be guilty because the defendant did not testify. The defendant is not required to testify. The decision on whether or not to testify is left to the defendant. You must not let this choice affect your deliberations in any way. Mere presence. Guilt cannot be established by the defendant's mere presence at a crime scene, mere association with another person at a crime scene, or mere knowledge that a crime is being committed. The fact that the defendant may have been present or knew that a crime was being committed does not in and of itself make the defendant guilty of the crime charged. One who is merely present is a passive observer who lacked criminal intent and did not participate in the crime. Voluntariness of defendant's statements. You must not consider any statements made by the defendant to a law enforcement officer unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily. A defendant's statement was not voluntary if it resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such weight to the defendant's statement as you feel it deserves under all the circumstances. Jury not to consider penalty. You must decide whether a defendant is guilty or not guilty by determining what the facts in the case are and applying these jury instructions. You must not consider the possible punishment when deciding on guilt. Punishment is left to the judge. Presumption of innocence, burden of proof. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means the state must prove each element of each charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find her guilty. If, on the other hand, you think there is a real possibility that she is not guilty, you must give her the benefit of the doubt and find her not guilty. Evidence of any kind. The state must prove guilt beyond a reasonable doubt on the evidence. The defendant is not required to produce evidence of any kind. The decision on whether to produce evidence is left to the defendant. The defendant's decision not to produce any evidence is not evidence of guilt. Voluntary act. Before you may convict the defendant of the charged crime, you must find that the state proved beyond a reasonable doubt that the defendant committed a voluntary act. A voluntary act means a bodily movement performed consciously and as a result of effort and determination. You must consider all the evidence in deciding whether the defendant committed the act voluntarily. Absence of other participant. The only matter for you to determine is whether the state has proved the defendant guilty beyond a reasonable doubt. The defendant's guilt or innocence is not affected by the fact that another person or persons might have participated or cooperated in the crime and is not on trial now. You should not guess about the reason any other person is absent from the courtroom. Motive. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdict. The charged offense. I will now tell you about the crime with which the defendant is charged. Count 1, conspiracy to commit first-degree murder. The crime of conspiracy to commit first-degree murder requires proof that the defendant, on or about July 11, 2019, with the intent to promote or aid in the commission of first-degree murder, agreed with Alexander Cox that at least one of them or another would engage in conduct constituting the offense of first-degree murder. The crime of first-degree premeditated murder requires proof that a person, 1, caused the death of another person, and 2, intended or knew that he or she would cause the death of another person, and 3, acted with premeditation. Premeditation means
life's better when you're under our roof. Save up to 23% by bundling your home and auto with us.
Honey, everything okay?
My friends are having a sleepover without me.
We're sleepover experts.
of time in which it occurs that distinguishes first-degree murder from second-degree murder. An act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. The time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. Elements of conspiracy. The crime of conspiracy to commit first-degree murder requires proof. 1, the defendant agreed with one or more persons that one of them or another person would engage in certain conduct, and 2, the defendant intended to promote or assist in the commission of such conduct, and 3, the intended conduct would constitute the crime of first-degree murder, and the defendant knew that such conduct was a crime. Scope of proof of conspiracy. To prove a conspiracy, it is not necessary to show a formal meeting or an express agreement. A conspiracy may be inferred from circumstances showing a common criminal objective and does not require proof that all means set forth in the charging document were agreed upon or actually used, nor that every person involved was a member of the conspiracy. Proof of membership in conspiracy. One may become a member of a conspiracy without full knowledge of all the details of the conspiracy. On the other hand, a person who has no knowledge of a conspiracy but happens to act in a way that furthers some object of the conspiracy does not thereby become a conspirator. Before you find that a defendant or any other person was a member of a conspiracy, the evidence must show beyond a reasonable doubt that the conspiracy was knowingly formed and that the defendant or another person knowingly participated in the unlawful plan with the intent to promote or assist the carrying out of the conspiracy. One who knowingly joins an existing conspiracy is as responsible as an originator or instigator of the conspiracy. A person understanding the unlawful character of a plan who knowingly encourages, advises, or assists in the undertaking thereby also becomes a conspirator. In determining whether a conspiracy exists, you should consider the actions and statements of all the alleged participants. However, in determining whether a particular defendant was a member of the conspiracy, you should consider only that person's acts and statements. A person cannot be bound by the acts or statements of other participants until it is established that a conspiracy existed and that person was one of its members. Justification for self-defense physical force. A person is justified in using or threatening deadly physical force in self-defense if the following 2 conditions existed. 1, a reasonable person in the situation would have believed that deadly physical force was immediately
all the people asking at closing
to protect against another's use or apparent attempted or threatened use of unlawful deadly physical force, and 2,
people asking at closing arguments happened yet. They always do this before closing arguments. Always.
Reasonable person in the situation.
Always.
A person may use deadly physical force in self-defense only to protect against another's use or apparent attempted or threatened use of deadly physical force. Self-defense justifies the use or threat of deadly physical force only while the apparent danger continues, and it ends when the apparent danger ends. The force used may not be greater than reasonably necessary to defend against the apparent danger. The use of deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate deadly physical danger appeared to be present. Actual danger is not necessary to justify the use of deadly physical force in self-defense. You must decide whether a reasonable person in a similar situation would believe that deadly physical force was immediately necessary to protect against another's use, attempted use, threatened use, apparent attempted use, apparent threatened use of unlawful deadly physical force. You must measure the person's belief against what a reasonable person in the situation would have believed. A person has no duty to retreat before threatening or using deadly physical force in self-defense if the person, 1, had a legal right to be in the place where the use or threatened deadly physical force in self-defense occurred, and 2, was not engaged in any unlawful act at the time when the use or threatened deadly physical force in self-defense occurred. If evidence was presented that raised this justification defense for count 1, conspiracy to commit first-degree murder, then the state has the burden of proving beyond a reasonable doubt that the defendant or co-conspirator did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Justification for defense of a third person. A person is justified in using or threatening physical force in defense of a third person if the following two conditions existed. 1, a reasonable person in the situation would have believed that physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person, and 2, the defendant used or threatened no more physical force than would have appeared necessary to a reasonable person in the situation. A defendant may use deadly physical force in defense of a third person only to protect against another's use, attempted use, apparent attempted use, threatened use of deadly physical force. Defense of a third person justifies the use of or threat of physical force or deadly physical force only while the danger continues, and it ends when the danger ends. The force used may not be greater than reasonably necessary to defend against the danger. Actual danger is not necessary to justify the use of physical force or deadly physical force in defense of a third person. The use of physical force or deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate physical danger appeared to be present. You must decide whether a reasonable person in a similar situation would believe that 1, physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person, or 2, deadly physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person. You must measure the person's belief against what a reasonable person in the situation would have believed. The state has the burden of proving beyond a reasonable doubt that the person did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Use of force in crime prevention. A person was justified in threatening or using physical force and/or deadly physical force against another if and to the extent the person reasonably believed that physical force or deadly physical force was immediately necessary to prevent another from committing or apparently committing the crime of aggravated assault. There is no duty to retreat before threatening or using deadly physical force. There is no requirement that any threat to the person's safety exists before the person may use physical force and/or deadly physical force. However, physical force and/or deadly physical force can be used only to the extent it appears reasonably and immediately necessary to prevent commission of the crime of aggravated assault. The person's use or threatened use of physical or deadly force is not limited to a person's home, residence, place of business, land the person owns or leases, or conveyance of any kind, but includes any place in this state where a person has a right to be. The person is presumed to have acted reasonably if the defendant reasonably believed he or she was acting to prevent the imminent or actual commission of aggravated assault. The person is justified in using physical force and/or deadly physical force against another person, even if that person is not actually committing or attempting to commit the crime, if the person reasonably believed he or she was preventing the commission of the crime. Actual danger is not necessary to justify the use of physical force or deadly physical force in crime prevention. If evidence was presented that raised this justification defense for first-degree murder, then the state has the burden of proving beyond a reasonable doubt that the person did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Non-justification for threat or use of physical force. A person is not justified in using or threatening physical force against another in response to verbal provocation alone, or if the defendant or co-conspirator provoked the other person's use or attempted use of unlawful physical force, unless 1, the defendant or co-conspirator withdrew from the encounter or clearly communicated to the other person the intent to withdraw with the reasonable belief that the defendant could not safely withdraw, and 2, the other person continued or attempted to use unlawful physical force against the defendant or co-conspirator. The state has the burden of proving beyond a reasonable doubt that the defendant and/or co-conspirator did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Definitions. Intentionally or with the intent to means that a person's objective is to cause that result or to engage in that conduct. Intent may be inferred from all the facts and circumstances disclosed by the evidence. It need not be established exclusively by direct sensory proof. The existence of intent is one of the questions of fact for your determination. Knowingly, willfully, or knew means that a person is aware or believes that his or her conduct is of that nature or that the circumstance exists. It does not require any knowledge of the unlawfulness of the act or omission. If the state is required to prove that the defendant acted knowingly, that requirement is satisfied if the state proves that the defendant acted intentionally. A defendant is criminally accountable for the conduct of another if the defendant is an accomplice of such other person in the commission of the offense, including any offense that is a natural and probable or reasonably foreseeable consequence of the offense for which the person was an accomplice. Accomplice means a person who, with the intent to promote or facilitate the commission of the offense, does any of the following. 1, solicits or commands another person to commit the offense, or 2, aids, counsels, agrees to aid, or attempts to aid another person in planning or committing the offense, or 3, provides means or opportunity to another person to commit the offense. Act means a bodily movement. Aggravated assault means a person intentionally, knowingly, or recklessly caused a physical injury to another person, or intentionally put another person in reasonable apprehension of imminent physical injury by either 1, causing serious physical injury to another person, or 2, using a deadly weapon or dangerous instrument. Conduct means an act or omission and its accompanying culpable mental state. Deadly weapon means anything designed for lethal use, including a firearm. Dangerous instrument means anything that is readily capable of causing death or serious physical injury under the circumstances in which it is used, attempted to be used, or threatened to be used. Deadly physical force means either 1, force which is used with the purpose of causing death or serious physical injury, or 2, force which in the manner of its use is capable of creating a substantial risk of causing death or serious physical injury. Unlawful means contrary to law, or where the context so requires, not permitted by law. Jury foreperson. The case will soon be submitted to you for your decision. When you go to the jury room, you will choose a foreperson. The role of jury foreperson is important, but please remember that the foreperson's opinion about the case is not more important than that of the other jurors. The opinions of each juror count equally. The jury foreperson's responsibilities include the following. 1, make sure every member of the jury is present during all discussions and deliberations. 2, make sure that the deliberations are conducted respectfully and that all issues are fully discussed. The discussions should be open and free so that every juror may participate. 3, all jurors should be allowed to state their views about the case and what they think the verdict should be and why. 4, all members must agree unanimously on any verdict. Therefore, the foreperson should count the votes to ensure that every juror has voted. 5, if you reach a verdict, fill out the verdict form and then sign the form on behalf of the jury. 6, if the jury reaches a verdict, the foreperson will inform the courtroom assistant. When the jury returns to the courtroom, the foreperson will bring the signed or unsigned verdict form as well as any question forms that may have been used. 7, when you return to the courtroom, the court will ask the foreperson whether the jury has reached any verdict. The foreperson will respond yes or no. The foreperson is not expected to read any verdict to the court. That will be done by the clerk. Closing instruction. In a few minutes, we're probably going to take a lunch break, and then after the lunch break, you will hear the closing arguments in this case. After that, the case will be submitted to you for decision. I suggest that you discuss and then set your deliberation schedule. You are in charge of your schedule and may set and vary it by agreement and the approval of the court. After you have decided on a schedule, please advise the courtroom assistant. You are to discuss the case and deliberate only when all jurors are together in the jury room. You are not to discuss the case with each other or anyone else during breaks or recesses. The admonition I have given you during the trial remains in effect when all of you are not in the jury room deliberating. After setting your schedule, I suggest that you next review the jury instructions and verdict form. It may be helpful for you to discuss the instructions and verdict form to make sure that you understand them. Again, during your deliberations, you must follow the instructions and refer to them to answer any questions about applicable law, procedure, and definitions. Should any of you or the jury as a whole have a question for me during your deliberations or wish to communicate with me on any other matter, please utilize the jury question form that we will provide you. Your question or message must be communicated to me in writing and must be signed by you or the foreperson. I will consider your question or note and consult with counsel before answering it in writing. I will answer it as quickly as possible. Remember that you are not to tell anyone, including me, how you stand numerically or otherwise until after you have reached a verdict or have been discharged. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or social media to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. All 12 of you must agree on the verdict. You must be unanimous. Once all 12 agree on a verdict, only the foreperson needs sign the verdict form on the line marked jury foreperson. You will be given one form of verdict. The verdict form reads as follows, and there is no significance to the order in which the options of guilty or not guilty are listed on the verdict form. So this is a sample verdict form at the end of your instructions. It indicates this is a sample. An official verdict form will be given to you by the courtroom assistant in the jury room. Verdict, count 1, conspiracy to commit first-degree murder. We, the jury, duly impaneled and sworn in the above entitled action and upon our oaths, do find the defendant, Vallow Daybell, as to the crime of conspiracy to commit first-degree murder occurring on or about July 11, 2019 as follows. Check only 1, and the options are not guilty or guilty. In order to break up the closing arguments as little as possible, we're going to take our lunch recess a little early and start a little early with those closing arguments after you recess. So we'll go ahead and recess for your lunch break. If we could have everyone ready to go in the jury room at 12:45, please remember the admonition.
All rise for the jury. Trying to give my eyes a little bit of a break by looking down.
However you book your hotel, first check Kayak to see what lots of people say about where you're planning to stay.
Want to try Ozempic?
So this is tirzepatide, and it is the #1 weight loss medication available right now. This is not only a GLP-1, but a GIP medication, which means it hits 2 hormones at once. So if you're looking for the best weight loss medication you can get, tirzepatide is the one. And if you're looking to get access to this, you can just take the quiz below, and we will ship this out within 24 hours to your door, just like that.
It is. It's Defense 20. No, it's Defense 20.
It's defense.
Well, it's got numbered.
Numbered different ways.
Oh,
It's going to be 200 and something.
okay. Yeah, give me a second. I'll figure that out. And should we put it on a CD?
Anywhere from 256 to 272. You'll have to figure out which one it is, but we can clarify that. Might have to look at the actual exhibits to determine which one it is.
Yeah.
Ladies and gentlemen, we're going to ask that you take all of your belongings with you for lunch.
Anything else?
That's all, Your Honor.
So,
Remind me to clarify which one it is when we get back from lunch, but your staff can look at or your team can look at the exhibits.
mortgage charges Vallow. Other couples we just don't know. We do know that closing arguments are happening. She has maintained her brother after the prosecutor shot and killed Vallow in self-defense during an altercation between Vallow and Daybell. The state has argued that Lori planned for her brother to kill Vallow so she can collect on his life insurance policy because she was having an affair with doomsday author Vallow Daybell, who would end up becoming Lori's husband after Vallow death. The judge read the jury their instructions. Closing arguments will begin later this afternoon, and a verdict will come as soon as today. Reporting live outside the Maricopa County Superior Courthouse, Heidi Hommel.
Personally, I'm like crying on the inside that they were there for like 30 minutes and they're going to lunch. Like, why? So $4:15 they're coming back. I'm just gonna